Hey Nick, hey Kathy, can y'all hear us? You are both on mute. Just nod, Kathy.
Yes, I can hear you just fine.
Okay, perfect. I'm gonna turn it over to the ladies here. All right. Hello, Kathy. Hello, Nick. I'm gonna give people just a couple more minutes to, and I see the thumbs up from Nick. Perfect. I'm gonna give people just a couple more minutes to trickle in, and then we'll get started. Learn how to do that blurring in the background. I'll see that. Yeah. I don't know how to do that. Kathy, I like it though.
Okay.
Oh, no, you're good. Focus on driving. I was just saying, I like how it's like focused on you, but it's blurred in the background. I don't know how to do that on mine, so I need to learn how to do it.
Oh yeah, it's in the settings. I'm just kind of floating on air, aren't I?
It's cool though, I like it. All right, we're at 1:05, so we can go ahead and get started. All right, well, good afternoon, Kathy and Nick. My name is Amy Smading. I'm with McMichael and Gray. Some people look that way. And this is Emily Raymond. She's the agent services rep with McMichael and Gray. Both of us are located inside of the Chat North office. We're actually right outside of the training room door. So y'all feel free to stop by with any questions that y'all have at any point related to closings, any questions in general. We'd both be happy to help. We do have a team email that's dedicated to the Chat North office that'll reach both Emily and I and the rest of our team. Emily's gonna type it into the Zoom call now so that y'all have that, but that goes to both of us. Emily, if you wanna put my cell number in there too. She'll add my cell phone as well, and if y'all just wanna get that saved in there, just let us know if you have any questions at all. But today, what I wanna accomplish is just kind of go over just from the start of going under contract all the way up through closing, what you can expect to see from McMichael and Gray, but it's really gonna be from really any closing firm, really around Atlanta or Georgia. But if y'all have any questions, please feel free to type it into, Zoom chat or just type on in here, ask me a question, I'll be happy to go over that. But yeah, we'll go ahead and start diving in. So basically, once you go under contract, the first thing that we're gonna need immediately is gonna be, of course, the fully executed contract from y'all. And when you send that, go ahead and include your client's contact information, whether that be email address is ideal, phone number is great. Reason being is that immediately once we receive that contract, we're gonna need to send out their information forms. For the buyer, we're gonna need to know, do they have a lender? Who is that lender? We need to request the title order from the lender. That's gonna detail, you know, what type of loan they have, how much it is, and we'll go through that just to make sure we have everything we need so there will be no closing delays. On the seller side, it's really, really, really important on the seller side. So on that seller information form, it's gonna have who holds the title to the property. We're gonna need their social in case there's any kind of liens or anything against the property. On that seller information form, they're gonna fill out if they have an open mortgage on the property. So we're gonna need that information so we can request a payout from their lender. It'll detail if there's an HOA, it'll give us the contact information for the HOA company, so we can order HOA contact information. And another couple of things that it's really important for is it'll detail to us, are they a resident of Georgia? Are they a United States citizen? I'm sure y'all know, but of course, if they are not residents of Georgia, if it wasn't, and we'll go through, if they're not, we go through a order of different things that would basically allow them to not have withholding. Biggest thing is gonna be whether they're primary residents, If it was, there would not be withholding. If it's an investment property, there typically will be. If it was not primary residence, they then have a third option where you can go through the capital gains. They would want to speak with an accountant or a tax advisor. Of course, on that, we can't give any advice regarding that, but they would go through and put in, you know, what they bought the property for, any renovations, any kind of other work on the property to try to get that down to where they would pay the least amount of taxes as possible. It would of course want to have your accountant or your tax advisor included on that. Hello, how are you? All right, well, we just got started, so I've got two people on Zoom here, but come on in, and my name's Amy Smading, I'm with McMichael and Emily with McMichael as well.
And I'm new with credit builders and I'm new with my guys. Living houses, in Atlanta, and I have one living on the contract, so very question.
Yeah, very nice.
So I need help with my command, but I need to ask for.
Yeah, with command, that'll definitely be someone within Keller Williams, if any contract or any kind of questions related to closing, that's what we're here for. So yeah, we're gonna go over a bunch of different topics here, but then especially at the end, or if you have any questions on what I'm talking about, just ask away. It'll help Kathy and me as well.
Thank you.
But we had actually just started talking about just right when you go to your contract, the importance of getting contact information for your clients, whether that be a buyer or a seller. And then also just the reasoning behind it. So for seller, a lot of times it's gonna be, we need to have information for their payoff, if they have a mortgage on the property, if there's an HOA, we need contact information to get that ordered. And then we also need to know, their residency, or they resident in Georgia, in a different state, are they a US citizen? And the reason for that is to the withholding that would be on the settlement statement. And I'll go into a little bit more on that in just a bit as well. But yeah, so that's really the importance for the seller, contact information sheet. And Kathy and Nick, did y'all have any questions on that while we're still on that topic? If you do pipe in, don't feel like you have to unmute it the whole time, but just pipe in and let us know. But again, so with the withholding, basically, all you need to know is if there's any questions on their residency, direct them to call us or whatever closing firm that they're closing with. If they're not a Georgia resident, or if it was not primary residence, or they cannot go through the capital gain portion, there would be a 3% withholding on the sales price. And that would be on the settlement statement, but that's just kind of something to let them know about going into it. If they're not a US citizen, or they don't meet the different qualifications to avoid the FERPA withholding, that's 15, I'm looking at the screen, I'm like, right? That's 15%. And with FERPA, there's also a couple different ways to avoid that depending on what the sales price is. I believe it's 300,000 or less. And if the buyer is going to use it as a primary residence, you can also potentially avoid FERPA. Again, don't go into that too deep with your clients because you don't want to give them tax advice, but direct them to us. And then if it goes into too deep of a layer for us, then we would of course advise them to talk to an accountant or a tax advisor. But just so y'all know, there is potentially a way to get around that depending on the sales price and the intent that the buyer intends to use the property for. So it's gotta be a primary residence, investment property. It's gonna have FERPA. They're not a US citizen, or they just don't meet the different requirements. And for the seller information form, if y'all are representing the seller in the transaction, make sure you're stressing the importance of them getting that information back to us. If we send it out, let's say on a Monday, and it takes them 2 weeks to complete, let's say there's an HOA on the property, we may not get that in time for closing. You don't want that to delay closing just because they're putting that information in there. Also, depending on if they have a payoff, some lenders I've seen that they're requiring a wet signature. So the form that we have is allowing them to do an e-signature. If the lender comes back, we work the payoff, and they say, nope, we want a wet signature. That's another couple days that's being added on, trying to obtain that information. I've seen it get close to having to push closing. Go ahead.
Sorry.
No, you're fine.
For example, my case is a little bit different because I'm invested in a real in completely housing. So my property is in my name, it's my LLC. So when you say the payoff has to be signed, because the lawyers, they request me and they send me the, request payoff letter. And I sign and give it all the information and send back to them. So in that case, I don't have to do any document with e-sign or yes.
So typically there is still gonna be information that the attorney's gonna need to gather from you, that may not be included with the payoff statement. On that form, it's gonna have like your tax identification number, and did you say it was titled in the LLC or individually?
Yeah, or
LLC, so we would need to have the tax ID for the LLC, because when you're signing the closing documents, you're gonna sign that 1099 that shows that you sold the property for the current tax year. It has to be on there or it flags it in our system. And that's just showing that you sold the property, but there's other information that we'll need from you as well on that seller information form. That's okay to be e-signed. For your payoff, if you've already been in contact with that lender and they've provided it for you, you've already signed it, that's not something that we would need your wet signature for or anything like that. But some lenders, when the attorney is requesting it directly from that lender for a payoff, that's when they will sometimes require a wet signature. We do not for the seller information form. We're totally fine with everything electronic at that point. Closing documents, of course, we're gonna need to have notarized with the original, all that kind of stuff. But for the seller information form, it's just particular payoff lender. So if you've already crossed that bridge, you're fine.
I'm fine.
Yeah.
Okay, thank you. And another question is, are you familiar with the commission or the fee process when you are investor and you are the owner and you have the LLC? So Mickey, she told me is if I do 2 houses a year, for each one is 500 the fee. Plus the FMLA or the commission. So I wanna make sure that part is clear with me and everything, how I can say, Keller Williams, how is the process?
Yeah, so that's a great question. Regarding the fees to Keller Williams, that'll definitely be something you want to discuss with them directly. But regarding how it's reflected on the closing statement for the attorney, all we would need is that instructions to closing attorney showing the different percentages. And if you're just taking a $500 fee, basically we would need a signed broker letter just stating this is the amount that's gonna be collected. Sometimes though, it'll be credited to you. So let's say that on the settlement statement, it shows if you were gonna take like 3% or whatnot as the listing side, but you're also the owner of the property.
Like 50 for me,
Yeah.
500 for Keller Williams,
Yeah.
and the 3% for the another side, realtor for my commission.
Yeah, so that would wanna be detailed on that instruction to closing attorney form, whether it's, 3% to the buyer side, 0 to the listing agent, however, $500 to Keller Williams. It just needs to be clearly detailed on that form.
Yeah.
And we would also want a broker letter just confirming this is the only amount going to Keller Williams, no other commission. That's totally fine. We just have to have that documented for our file so we can reflect it correctly ourselves. But yeah, that's not a problem at all. But regarding the fees, just make sure you chat with them and then relay that. You'll wanna ask, I would ask probably Carrie, and Linda Betts on that.
Okay.
They'll be able to direct you as to who to chat with within that Keller Williams.
I'm so sorry, but I have many questions because it's something that I learning now.
Yeah.
Besides, not before, because before I don't have to do the contract and everything, there was for the another realtor. I have to check my documents. If possible, can you help me to check if I do the right way when we done?
Yeah. Yeah, I can definitely go through that with you. Yeah.
And then Kathy had one quick question. How does seller enforce a divorce decree directing spouse to quit claim but has not done so, and their whereabouts are now unknown? And Kathy, if you want to specify, feel free to, or
So typically on that, and a lot of times, Kathy, it's gonna be specific, it's not like an overall black and white answer. But on this one, my question would be, were both spouses represented by an attorney, do you know? Oh, you're on mute.
I don't know about both of them, but at least one was, and that was my first response, was to try to get assistance from the divorce attorney. But the lady is either in and out of rehab, or she's just missing. So they can't serve her because the last known address is the marital home. So they're trying to figure out how to resolve that before they put their house up for sale in the spring. Because it's best to resolve these things before you put it on the market and cause any
Yeah,
concern.
absolutely. I would definitely, if that spouse, the one that was represented by the attorney, of course, go that route. If it was not the spouse represented by an attorney, I would actually ask the attorney for the spouse that did have the attorney, ask them what they do in that situation, because it may just be a point where they've got to track that person down to get that actually executed. And I'm actually a little bit surprised that they didn't go ahead and get that. If it's already finalized, there's a decree, I'm a little bit surprised they didn't go ahead and get that quitclaim deed executed.
It's been about 5 years. So I told
Oh,
him,
goodness.
so my first thing, again, it's just casual for, interaction, was to either hire a skip tracer or,
Yeah,
check to see at vital records to see if she still is with us.
yeah. And that, of course, would create a whole different can of worms if something happened where they're not alive or whatnot, or unable to be found. You'd have to go through a whole different process on that. You may want to even get a judge involved, to have some type of order signed, allowing the spouse that is still available to sign. But that would definitely be an interesting one on what their next steps would be if they're not able to find that person, or if they passed, or they're just missing, or whatever the case may be. But yeah, I would first try to get that attorney involved that handled the divorce to see if they have any, I'm sure that's happened before, but just to kind of see what they advise on the next steps, but.
Okay. Thank you. I didn't want to, take too much of the time and things, but if you had a step by step, that would have been great. But it sounds like you said, it's case by case.
Yeah, it is, unfortunately, in that situation, but yeah, definitely anything you can handle prior to closing, prior to listing it, that's ideal. But yeah, 5 years, hopefully they can find them.
Yeah. Okay, thank you.
Yeah, you're welcome. And actually, we'll go ahead and switch to that point. For especially if you're a listing agent, those are the types of things that you're gonna wanna address with your clients immediately once you hear something. So a lot of the big not that they're red flags, but the big takeaway that you're gonna wanna have if you hear there's a divorce, you're gonna wanna ask them, and it's not being nosy, it's just being, prepared and getting ready for a listing. You're gonna wanna know the status of the divorce. Are you talking about it? Have you filed for divorce? Is the court involved? Is there already a decree? Is it finalized? Because there's a very big difference on we're thinking about it versus it's been filed versus it's finalized. Because if it's pending, then you can typically not sell. There are cases where you can, but again, that's going to require both parties being represented by attorneys. And at that point, they're going to have to draw up some type of documentation allowing the sale. But the catch there is, even if there are attorneys involved, many times you still have to have a judge sign off that the property is able to be sold at that time. If the decree is finalized, which it is in this case for Kathy's clients, that's the ideal situation. However, this is not ideal. If one of those spouses is missing, because they're gonna need a quitclaim deed signed to the other spouse, allowing, you gotta have both parties sign to convey the property over to the buyer, or to convey it to the other spouse who then sells it to the buyer. But there's a lot of different catches. If they have not filed yet, I'm not telling you to tell your client, don't file for divorce, but they need to understand that that could delay the property being listed, the property ultimately being sold, if they have not filed, because at that point, it's gonna have to typically be finalized, which as y'all know, can take a couple months. So yeah, with divorces, it can definitely be tricky, but immediately once you hear any talk of that, just kind of see what the status is, and you can always get us or, you know, an attorney to take a look at it and kind of advise as well. Another thing that y'all are gonna wanna have in the back of your head is regarding probate. This one has been huge lately. I've had a lot of probate questions. I actually had one today. If you are aware that the property is owned by someone that has passed, the first thing that you're gonna wanna do is get us to pull the deed for you and take a look at how title is held. So let's say that Emily and I own a property and we hold title as tenants in common. If something happens to me, Emily can't sell that property without my family going through the probate process. Because as tenants in common, we both own 50% undivided interest in the property. So at that point, once I pass, Emily still owns her 50% and my estate holds 50%. To contradict that, if we held title as joint tenants with right to survivorship, which that wording has to be on the deed, it has to specifically say Amy and Emily as joint tenants with right to survivorship. If you see that language on the deed, if something happens to me, typically all y'all are gonna need to let them know is that you need my death certificate. And in that situation, property would revert fully over to Emily without having to go through probate. On the title side, we're gonna request that immediately. If we know that one of the parties has passed, we're gonna say, where's the death certificate for the joint tenant that has passed? And then we will actually draft up an affidavit that will report at closing. And it's basically just Emily signing it saying, yes, I own the property as joint tenants with Amy. She passed on such and such date, and now I own the property fully. And that's really just to clear up anything on title side for whenever that current buyer sells it in the future. That way they know there's no one that's gonna be contesting it on my side because we're joint tenants. But again, that's gonna be, if you hear one of the persons has passed, look at that deed, because if you don't see that joint tenancy language, your next question, are you in probate? Has that been finalized? What is the process on that? And if they say, oh, we've already gone through probate, tell them to go ahead and get those documents all together, because that's gonna be the next thing the closing attorney asks for. Where's the letters testamentary? Where's the order appointing the executor of the estate? There's a bunch of different documents. It's typically gonna be the petition that was sent to the court, which will detail the family members of that person who has passed. All of those documents we have to take a look at. We had one closing, I think it's actually either closed on Friday or it possibly is closing today. We had one, Emily Clutter remembers this phone call. The property was listed, they were under contract, and I got the seller on the phone. They did not go through probate process, and it was required that they go through probate. This seller,
No? They don't know or they don't do.
they didn't do probate yet because they thought that the will would suffice, because it showed, basically the will stated Amy's gonna be the executor of the property. And Amy as executor has power to sell my properties. That's the only document that he had that showed that, but I was trying to explain to him, just because the will says that you're gonna be the executor, doesn't mean you're actually appointed as the executor yet. There was no probate done, and they thought that just the will said it, that they had authority to sign the deed to convey to the buyer. So at that point, of course, closing was halted. We had to get them to go to an estate planning attorney to get that probate process started. But the listing agent was told everything was good, so they didn't know that they had not gone through probate, because the seller thought, oh, I have the will. The will is enough, and it's not. And so that was one thing that, and of course, the listing agent was mortified because they thought, oh, we have everything. But that's where, especially if you're a listing agent, go ahead and request that, have them send it to you, and if they can't send it to you, that's gonna be your red flag. And you may wanna get an attorney on the phone, because at that point, we'll say, okay, you have this, and then. And that could have maybe caught it, but even after a couple of phone calls with the seller, he did not understand that the will was not enough.
It's hard.
It's a lot of, I definitely get the confusion, but especially on our side, we've seen it so many times that it's usually, with the exception of that particular one, it's usually a little bit more, they'll understand it and see why we're asking for what we're asking for. We're not trying to be nosy or anything like that. We just have to, of course, have all of our ducks in a row. But if y'all get pushback on that and they can't provide documents, that's typically gonna be something that y'all need to say, hold on, why are you not able to provide it to me? And I've even had sometimes where the seller doesn't wanna provide it to their agent, they say, I wanna send it directly to an attorney. At that point, even if we're not handling the closing, I'd be happy to take a look at it for y'all, just to make sure that y'all have everything you need to have a smooth closing. Luckily, the buyer on that one really wanted the property, so they hung in there.
So they wait.
So we got this contract, I wanna say back in like June.
No.
It has been that long. I mean, it's been a while, and they finally were able to get everything and it's ready. I think it was supposed to go Friday, but there was one other thing that we were waiting on, but.
You know what, I'm worked all my life with bank and in experience. And always I ask everything. That's why I'm here today, because I have many questions about my children. And it's like little details that you never know what's going on.
Yeah,
And when you don't know, you don't know how you can provide the closing fast and the move like you say.
yeah, definitely, it's always better to ask for too much and have it, and then be able to provide that rather than not have enough, so
Exactly.
it's definitely very, very, very important. But that was just one example. Another example, I know I've used it before, if y'all have been at the team meeting, we had one closing, when I was down in our Florida office, but it's the same law with the joint tenancy language. So basically, the property was owned by the father. He had an only child, his daughter. She had signed, or he had signed a power of attorney giving her the power to sign on his behalf. And he was not doing well. We were aware of the situation. I was very good friends with the agent down in Florida. So he reached out to me and said, what can we do here? Knowing the family history and that there was not, multiple people that would have taken under his estate, and it was just the daughter. We felt comfortable doing a joint tenancy deed at that time to add her onto title.
And she was older or younger?
It was his daughter.
Yeah,
Yeah,
and she was like over 21.
yeah, I think she was in her 30s or 40s.
Oh, okay.
But she would have been the only person that would have taken under his estate anyway. So at that point, we felt comfortable adding her to the deed. If it had been, he had 5 children, we were adding just one, I probably would not have felt comfortable doing that without taking a look at his will and seeing who else could have. But this situation, it was fine. But what we did was have him sign a joint tenancy deed from himself to both of them, so that if something happened to him, the property could revert fully to her and she would still be able to go through with the sale. We get up to closing, we had sent her documents, to sign on his behalf. She signed everything, and when we have a power of attorney, we do what's called an alive and well call on the day of closing. And what that's doing is we are confirming with that person that they still want that other person to sign on their behalf and make sure that they're alive and that they still intend to sell the property. We go through, a list of things. I called her to do the live and well call. She was supposed to be with her dad. He had passed the day before.
I know.
And so at that point, she had executed documents. But as I'm sure y'all know, if there's a power of attorney and that person has passed, that power of attorney dies with them. You can no longer sign power of attorney for someone that's passed. So at this point, unfortunately he passed, but luckily we had done the deed to where all we needed to do was redraft documents, request a death certificate, and it was still able to proceed to closing. Had we not done that deed that added her on there, that process would have stopped right there and the property would have had to gone through probate. So there's, given the situation, that one worked out because it was an only child who was gonna inherit all of his estate anyway. I was comfortable doing the deed, but there are just different things if you're aware of sickness or illness, or someone maybe not, knowing what they're doing. If there's a mental capacity issue, there's different things that we would need to do. In that case, we typically are gonna have to get a physician involved and have them write something that says this person, you know, they're still mentally well enough to go, they know what they're doing. And they can proceed to closing, X, Y, Z, there's a bunch of different factors, but the sooner that we or whatever attorney you're working with knows of those issues, the smoother your closing is gonna be. We've just gotta know of things. If it's a surprise at the closing table, that's probably not gonna close. Realistically, it's probably not. And that's the last thing that you want. I've said this so many times, your closing can be smooth, and then if you get to the closing table and issues come up, that is the last thing that your client is gonna remember. And they may not recommend you, they may not use you again, if that's the last image that they have with something happening at closing. And especially if it's something that, if you had looped us in, we're able to help with, we wanna make y'all look good. We wanna make y'all look good, let us take the heat for whatever things come up, but let us also work with you to help resolve stuff before it gets to that point. That's really a big takeaway from all of this that I wanna talk about, is just letting us intercept and solve whatever issues there are as soon as possible. Another thing with power of attorneys that I've come in contact with lately is the type of power of attorney. So when y'all are having one of your clients do a power of attorney, the type of power of attorney document that we need is a specific power of attorney. And that specific power of attorney will say on there, you know, this person has authority to sell this particular property. And it usually has a time frame that would expire. But I've had a lot of times, especially recently, where the agent will send me what their client has sent them, which will be a durable power of attorney or a general power of attorney. Those are typically estate planning documents, and it's supposed to cover, you know, finances, bank accounts, anything like that. It's not the type of power of attorney that we're looking for. I'm not saying we can't use it, but there's gotta be a circumstance that's outstanding that they would not be able to sign another document. The underwriter for our title, even if it's a cash closing, we still have our title underwriter, and they just want to be able to confirm that that person did have authority to sell that particular property or to purchase, whichever side you're on. But if there's just a durable or a general, they're gonna say, why can't they sign another one? So just be ready for that. If your client provides that, let them know, hey, thank you for sending me this power of attorney. The closing attorney may send you an additional document that they're gonna ask to get signed. And it basically, the main difference is that it is specific to that property. It's not an overall power to do whatever they want. It's specific to that transaction. So that's the catch. So just keep that in mind if they do say, oh, I have a power of attorney already. Just say, hey, they may still request another one. We had one instance, I think 2 weeks ago, where there was a general power of attorney, and the father he had been a roofer, and it was a really sad story, but his fingertips, like he was not able to answer phone calls, he was not able to physically sign documents well because his fingertips had burned off, I guess, when he was younger. So like the skin part.
So they spot all over the fingers, so you cannot do fingerprints or anything?
Anything like that. I don't know the specifics on fingerprints, but I know that even to answer a phone call, because you have to slide, he's not able to do that. And so, but to physically write anything was really painful for him. And they had documentation from a doctor that anything with his hands was very painful for him. And so at that point, when we requested an additional power of attorney, of course, we got some pushback. So I had to inquire further. That's the only reason I have all that specific information on his hand. But once I relayed that to the underwriter, they allowed us to go ahead and use that because he was physically not able. He was totally mentally with it. It was nothing on capacity issue. It was purely the physical part of, he's already done this.
The document is gonna be low and not.
Exactly, yeah, so the doctor had documented everything like that. I forwarded all that information over to our title underwriter, and especially because there was no mental problems, it was purely physical, they were fine with it. So again, as long as we're aware of why they could not sign another one, or it would be extremely difficult or painful to do it. We just need to know all that kind of information. That way we can relay that over there, get the approval, and keep on moving with the process. But yeah, that was actually really sad. I had never heard that before. But another thing, just for y'all, for your sellers especially, and a lot of this is for sellers, but it could also be for buyers, is just be aware of who your seller is. So if the seller is an individual, that's typically not gonna be any issues, but if you are seeing that your seller is an LLC, or a corporation, or if it's a, trust, or anything like that, that's gonna immediately be y'all's flag to get them to go ahead and get their documents together. And also for sellers, for their proceeds, whoever the owner of record is, whether that's an individual, an LLC, a corporation, that's who is due the proceeds. So if the property is owned by Amy and Emily LLC, and your client gets to closing and they have wire instructions that go to Emily Raymond and not Amy and Emily LLC, that's a problem. It's got to go to the LLC. If it's the Amy and Emily trust, the proceeds have to go to the trust. So, we had one closing, and I'll see if y'all can pick out the problem here. The seller was a trust selling the property. They were also purchasing a property with our law firm. But the catch here, selling is a trust and buying is an individual.
Can't have to change the
Exactly, so
contract or the title or.
So they could have changed the contract to where they were buying as the trust. And that would have been fine, because we can typically, if it's closing with us, we'll do an internal ledger transfer, and it's no problem. They don't even have to fill out the proceeds form that we would typically require. But the problem here, of course, is that they're selling as a trust. And they're
Different name.
different entities, exactly. So what we had to do, and they did not have a trust account. So basically, that's a great question. I don't know how they had been operating without a trust account, but they did not have any wire instructions to go to the trust at that point. They had to go to the sale went through, but we had to hold the proceeds, and they had to delay their purchase in order for the bank to get an account set up for the trust. So that definitely delayed them, but what ultimately happened was we had to wire funds to the trust. The trust then transferred it however they want to handle it, and that is not, as long as you're paying the seller, what they do with it after, we don't care. Yeah, after we have dispersed to the owner of the property, what they do after that is totally up to them. But what happened there was we had to wire it to the trust. They did whatever they needed to do to get it to their individual account, and the individual account had to wire money for their purchase back to us. But they initially, of course, are at closing thinking, just transfer it to my purchase. But we couldn't do that because it was two different entities. It was the trust versus them as an individual. So that was where the catch came. But just the takeaway from that is just make sure if your seller is an LLC, if they're an estate, that's another one. It can't go to, the son, who is ultimately, even if they're the sole heir of the estate, it can't go to the son. It has to go to the estate of the deceased. And then at that point, the executor of the estate would distribute it to the son or whoever it is detailed under their documents. But we can't just bypass that step. It's got to still go to the owner, which would be the estate. But that's just some other things to think about. Another thing that I've seen with an LLC, if there's an LLC, what the opposing attorney is going to request is the operating agreement. And that operating agreement is going to be a document that's drawn up that's going to say who the member is, who the manager is of that LLC. And that's the person that needs to sign documents on behalf of the LLC. So even when you're doing your contracts, that's going to be something, you're going to need that to say, okay, the Amy and Emily LLC, who's the signer? Is it Amy? Is it Emily? Is it both of them? Those documents are going to be detailing who that is. We have had a couple where it's single member LLC. So if it's the Amy LLC, I'm the only member. They a lot of times don't have an operating agreement. That's not necessarily a deal killer, but what needs to happen in that situation is they have a resolution drawn up, and all that resolution is saying is, you know, Amy's the only member of the LLC, and I have full authority to sign on behalf of the LLC. I've drafted those for some of our closings, I don't charge a fee for it or anything like that, but I just need to be aware of it, so I know that I need to draw that up. So that's another thing though, when y'all are doing your contracts, you're gonna wanna ask them for an operating agreement. And then if you have questions, send it over to me, I'll happily take a look at it for you. But that's gonna be on your contract, you're gonna wanna have the Amy LLC, and you're gonna wanna have Amy Spading signing as a member. So I'll help y'all with,
Yeah,
the wording and all that.
I don't think so, that I, have already in command
Okay,
if I needed to. I have in my
Yeah.
computer and everything, all the documentation.
yeah. Yeah, any questions y'all have, that's what we're here for. But then I'm thinking it'd be the same thing if you know that your seller is an estate. I would be happy to take a look at the documents as long as they have them and help you with the signature line on that, because you're not gonna wanna have the seller, you know, again, we'll go back to the scenario with me and Emily. If we're joint tenants and Emily is signing, or excuse me, if we're tenants in common, where it's my estate and Emily are the sellers of the property, you're not gonna wanna have Emily sign individually and Emily sign for me as well. You're gonna need the executor of my estate to sign. So you wanna make sure you have that wording correct on the contracts. So anything like that, just let us know and we'll be happy to help you with the signature lines. But yeah, it's definitely a lot, but that's what we're here for, so. Yeah, of course. And another thing I wanna talk to y'all about is also wire instructions. Just make sure that if you're on the buyer side, they know that they need to get that wire in ASAP. If we're holding earnest money, we'll send out our wire instructions. If Keller Williams is holding earnest money, you know, get that information from the market center, or they can send the check in for them. But for us, we're gonna require a wire for earnest money if we're holding it. But we also, for their final cash to close, we have to have that as a wire as well. Y'all never wanna be the middleman for wire instructions. Don't have, you know, anyone send you wire instructions that you then forward to your client. Do not be the middleman. Always have them reach out directly to us, and we'll send that out to you or to the client directly so they can get it wired into us. But just be very, very cautious with wire instructions. Always have them call and confirm it. There's a lot of wire fraud out there, and you don't want them to be following the wrong instructions and the wire goes, who knows where.
When, in this case, in my case, they hold the lawyers that they choose for the closing, and they have the wire and everything, so I don't have to
That's
do
perfect.
anything with that, only send to you guys the wire approved that they have for the first time.
Yeah, just always, even if it's, you know, whatever attorney's holding it, just always have them contact the attorney's office directly, just to confirm those wire instructions prior to them sending it. If the attorney's already confirmed receipt, then you're fine.
Okay.
But just for future, I would always have them call whoever they're sending the money to and make sure they're calling a number that you already talked to somebody at, and not someone emailing and saying, hey, call me at this number to confirm wire instructions. So that could be the person that's trying to intercept and get that wire. So you have a contact at that attorney's office, that is who I would go to directly, just to get that confirmed. But yeah, always go with a confirmed number, not someone coming in and saying, hey, it's Amy, here's my new phone number, call here and confirm the wire instructions. No, go with who you know and make sure that's a valid number that you or the client are calling. Another thing, and I know this may seem silly, always make sure your clients are bringing identification to closing. Can't tell you how many times I've gotten to closing and someone brings an expired passport or expired documents. It's got to be a valid photo ID. It can't be a Sam's Club card for their primary identification. If it's a secondary, I will take a library card. I don't care. But it has to be a government issued, non-expired photo ID for their primary identification. So driver's license or passport, military ID, anything that's government issued that's not expired, we'll take that. And then if the secondary is required, I'll take anything that's got their name on it. But also speaking of names on documents, be very, very careful if you see, let's say someone's either going through a divorce, they're getting married, or they held title in a different name. Make sure if you hear that or see that, y'all are requesting or telling them to send it to the attorney what the name change was from. So if your client got married during the time they purchased the property and now they're selling it and their name on the title was Amy Blackman, you're gonna say, okay, what was the name change? Oh, I got married. Okay, you're gonna need to provide your marriage certificate to the closing attorney. And at that point, we'll handle it. We'll do a now known as or formerly known as language on the deed. But we've gotta have that, whether it was marriage, divorce, people just wanting to change their name, we need a court order, whatever it is, we have to have that documentation. And that's also something that you're gonna want them to provide to us early in the process,
Yeah,
but just keep that in mind. And that's another reason that we send out those buyer information, seller information forms, is we're gonna pull title or have our title examiner pull title of the property. So if we see the property was held as Amy Blackman, but then I have a seller information form come in that says Amy Spading, I'm gonna immediately say, it's probably the same person, but I need some type of document showing that this is the same person, so we can get the documents prepared correctly. But that's just another thing to keep in mind. And on that note, if your client, let's say the clients are engaged at the time that they purchased the property and you're representing them on the buyer side. If they ask you, hey, do we need to do a deed later changing his or her name? They don't have to is the answer. They don't have to do it at that time. They can always do it whenever they sell the property. They would just need to, let the attorney know again so they can get the documents prepared. But with that said, if they do change their name and they do want a deed done correcting it, make sure if it's a homestead property, that they know that they would need to refile for homestead exemption. So anytime there's a deed done, the county is gonna see that and they're gonna drop the homestead exemption off the property. So imagine if your client owns property, they're still living there and they want a deed done just to change their name. And then the next year for taxes, they get that bill and prices have gone up. They're not gonna be super happy. So just make sure all y'all need to do is just let them know. Anytime there's a deed done that's recorded, whether it's changing your name, correcting a typo, refile for that homestead exemption. Because otherwise it will fall off the property.
wow.
So that's one thing, a lot of people don't realize that, but it will happen. So and it's just another thing, it's another touch that y'all can reach out to your clients for, but it's just another thing to keep in mind that it will fall off the property if they don't refile.
In Georgia, when people, they live like not married, live together, the wife, the wife and husband, they have rights when they buy something together or no? It's like only, for example, he buy in his name, but it was with her in that period of time for 5 years. Is they have the right, the wife have any right for that property because they're not married. Or no?
So if they're not married and her name is not on the title of your question, it's, if they split up and she was wanting a portion of the proceeds, she would have an uphill battle, is the answer. I'm not saying she wouldn't be entitled to anything, but she would have to get an attorney involved for sure. They would most likely do a source of funds, and if she contributed a lot to the property, she would potentially have an argument, but just purely from the deed itself, there's not gonna be any argument, especially at the closing, because the closing law firm, like I said, they're gonna pay the proceeds to the owner of the property.
Yeah.
And, face of the deed is gonna show the owner of the property is him in that situation. But again, if you got an attorney involved, there could be an argument that, hey, she put $100,000 of her property or her funds into it for renovations or whatever. Yeah, but you would want an attorney involved, and there's not a hard answer, yes or no on that,
Yeah.
but it would be.
People, they have that situation sometimes and they kind of say, oh no, this part is mine, but they don't have any.
Yeah, and at that point, they're gonna wanna get an attorney involved. But that actually brings up another point, that if you are doing a closing, where they're not married, you can't, there's a due on sale clause in the actual mortgage document itself, where at closing, you can't just add whoever you want to the deed. So basically, let's say, you have a couple that's engaged, and one of the fiancés is on the contract, that is gonna be the only person that's on that deed at that time. So if they're at closing and they say, oh, I wanna add my fiancé to the deed, can't do it. In that due on sale clause, there's a provision that says that that loan would be called due in full at the time that title changes, if there's anyone added to the title that the lender is not aware of. The exceptions to the due on sale clause are a spouse and an adult child. Those are the only two exceptions that the lender says, okay, you can add that person to the title and we will not call it in full. In reality, is the lender actually gonna do that if you're making your payments? Probably not, but we cannot advise you that that's a good idea to do that. I'm gonna always tell you, we definitely can't do it. If they did it themselves, nothing I can do about it, but the lender could call the loan in full at that point. So we've had people who either wanna add a fiance to title, and at that point I say, just wait till you're married, give us the marriage certificate, and we can add once you're married, no problem. But to get around that, what you're gonna wanna do, if you do want multiple people added to title, you're gonna wanna add them as a borrower, or excuse me, as a buyer on the contract. Even if they're not on the loan, they could be a non-borrower on title. At that point, the lender would need to approve of it as well, just to make sure they're okay with that person being added. But that is generally the only way you can get around it, if there's a loan involved. If it's a cash closing, you can add whoever you want on the title, it doesn't matter. But if it's a lender involved, they have to be okay with that. But you can't just go adding a sister, a brother, a parent even. And that's been a lot of times, if the parent's gonna be their resident, so maybe their child is the only one that's gonna be a borrower on the home. You can't just add the parent on there, it has to be approved by the lender. So that's one other catch that you'll kind of wanna keep your eye on if you do know, the situation of who was trying to be on the title of the home. Just try to grab that before it gets to a closing table, so you don't have anyone upset at the closing. But I have seen those actually a lot more often than you would think.
Really?
Oh, yeah, especially if it's, they're buying it for, a parent that's gonna be living there and the parent wants to be on the title to the home. If there's a lender involved, you can't do that without their, approval ahead of time. But I think there's just a couple last things that I do wanna talk to y'all about. A 1031 exchange. Have y'all ever done anything with a 1031 exchange at all? No, Kathy, Nick?
The only thing I remember is it has to be, is it type of property to type of property, like residential to residential or commercial and commercial exchange? Am I
Yeah,
right,
and
or-
yeah, that's correct, and it's gonna be an investment property, it can't be like a primary residence or anything like that. But the biggest thing that I just wanna make sure y'all know of for that is you've gotta have, for your seller, if they're selling a property and they wanna use the 1031 exchange, they need to have a company that they already have in mind ahead of time, because they do not wanna get under contract and then not be able to get that 1031 involved soon enough, because the minute that property sells, wherever the proceeds are going, if that goes to the seller, that's a taxable event the minute that wire hits their account. They just have to know that they need to have that qualified intermediary, which is the 1031. They need to have them ahead of time, and there's also that timeline, it's typically 90 days, where they have to identify the property that they're gonna be exchanging it for ultimately. So you just wanna make sure that they have that already lined up, they've already spoken to someone, they're able to take on that exchange for them. But a lot of times it was more when I was down in our Florida office, down in Denton, it's a lot of investment properties for people, but we had one, the 1031 was not taken on any new clients. and they were scrambled. They did end up finding someone that was able to help them. But the 1031 that they were trying to use was not taking on additional clients at that time. And so they started scrambling, trying to find someone that would take it on at that time in that time frame that they needed to close. That's kind of the one that really that sticks out in my mind, to where you definitely want to make sure that they have someone that they've already spoken to before going under contract. That's my advice.
Does it 1031?
Yeah, that's a 1031 exchange company. It's basically like a tax deferral. So instead of the seller selling an investment property, receiving the proceeds that they would be taxed on, they're going through the 1031 exchange. So on the documents, there's never anything that goes to the seller. It goes to the 1031. They hold the proceeds for the seller. They hold that until that seller has identified their property that they're going to purchase. And then the 1031 on the purchase side would wire the money so that they could purchase it. And the seller would, of course, if there's any shortage, would require more funds or whatnot. But it's basically so that the proceeds never hit the seller, because that's the taxable event, and that's what they're trying to avoid. So it's just like a tax deferral, but they're called the qualified intermediary, is that middleman. So that middleman is who helps to facilitate that 1031 exchange.
Do you see next question?
Oh, no, let's see.
Is it a rare?
No, it's not really rare, it's just that it's more for investors, and if it's an investment property, that you've gotta have that. It's rare in the sense that not a lot of people are utilizing it, but there are a lot of 1031s that people do try to do. But again, if they have an investment property and they're just wanting to sell it and they want the proceeds, of course, they're not gonna go through the 1031 exchange. But it is, especially for people who are doing flips or whatnot, it is a way for them to save on those taxes. Did that answer your question? I don't know if that was fully what you're getting at. But yeah, and if y'all have questions on a 1031 exchange, we have a couple companies that we've worked with a good bit, as well, that we could send, contact information for you to pass to your client. But it's just good to think about, if you have a client that's selling an investment property and you know that they're wanting to buy another investment property, they're probably gonna want to use a 1031 exchange so that they have less taxes that are due from them at that time.
That's great to know. I didn't know that you could help facilitate that. That's good information.
Yeah, we have a bunch of different companies that we work with. Again, back for that one in Florida, that one of the companies at that time was not taking additional people. I think we're past that point now because it has slowed down just a little bit. But it's always good to be in contact, have your client be in contact early in the process so that you don't run into that scramble at the last minute. Let's see, yes, yeah. That's exactly right, Nick. All right, do we have any other questions? We are right at the end of the class, but again, if y'all have any specifics, I know you're gonna come chat with us after the class. But thank y'all so much for joining us. Again, I know Emily put in our direct contact information. Please reach out with any questions that y'all have. There's nothing that's a silly question to us. I would much rather y'all reach out to me and have us address it prior to anything, going sideways with your clients. But if y'all even want me to delve in further on any other information or something I didn't cover today, please let us know, and I'd be happy to either do a whole nother class or just do a one-on-one sit down with y'all. Anything that'll help you with your business, would be more than happy to help.
I'm just gonna go myself.
Okay, and it looks like Emily's putting her cell number in here, but y'all have a great rest of the day. Thank you for joining us.
Thank you for having us. I appreciate the Zoom.
Yeah. We're looking forward to meeting y'all in person soon as well. All right, so we got your questions.
I'm sorry, I can't hear me.
I do.
Okay, and I will show you and you go in if I have everything.
Yeah.